So, the general conditions of liability in tort. There are certain conditions which must exist before a person is held liable in tort. So, after examining the various definitions, the element which have come before us are in fact the conditions on which the tortious liability is determined. So here the conditions are the elements or following. Like the first one is to be the wrongful act, legal damage, and legal remedy. So, out of which the first one is wrongful act. So, to determine the liability in tort, it must be proved that the act done by the defendant was a wrongful act. So, the wrongful act is an act which is done without any lawful justification. So, the act of the defendant becomes a wrongful act only when there is a violation of a legal right of another. So, if the act complained of does not violate the legal right of another person, so hence that would not at all be a tort. So, violation of moral, social, and religious duties, it is not at all, which does not come under the category of torts. So, thus, in the tort, the plaintiff has to very clearly prove that his legal rights have been violated by the act of the defendant. So, the tortious liability thus arises by both an act or an admission to do an act. For example, by doing an act which is prohibited or by violating another's legal right or by violating one's own duties, thus where legal rights of another is violated, there is violation of legal duty by the wrongdoers. So, in both the situation, his act constitutes a tort. So, rights may be divided into two kinds. One is public rights and the private rights. So, public rights are those rights which belong to the members of the state in general. So, every person of the public has a right to walk on the road. So, to take water from a river and so on. So, when a public right is violated, no action in tort shall be taken unless the plaintiff suffers a special and substantial damage in addition to the damage suffered by him in common to the public in general. So, for instance, A fixes a bamboo across a public road, so by which the whole road is blocked. So any person who passes that way has to take a turn and go. So in this case, no individual can file a suit against A, but if B, while walking on the road in a dark night, strikes against the bamboo and is injured, yes, of course, he can sue A for damages as he has suffered the special damages in addition to the inconvenience suffered by the public in general. So, this is said to be the wrongful act. So, what is legal damage? So, damage is the direct result of the defendant's wrongful act. But there is a distinction between damage and damages. So, what is meant by damage? Damage means the harm done to the person by the wrongful act of the defendant's act, while damages is the compensation which is given to the plaintiff. So, the main object of the law of torts is to protect from harm being caused to the person, trust, and prestige of a person. So, here in law of torts, thus an action for damages lies for infringement of individuals' legal rights. But it is not every damage that is the damages in the eyes of law. So, in an action in the torts, the plaintiff has to prove that he has suffered some legal damage from the defendant's wrongful act. So, there may be a wrong caused to a person, but if the actual damage is not caused by him, no action in tort will be maintainable. So, legal damage is neither identical to actionable or the damage, or it is necessarily pecuniary. So, where there is no any violation of legal right of a person, so there does not exist any tort. So, but even if he is going to suffer some pecuniary damages also, loss also, then too, so there will be no any action in tort. But in case of violation of a person's legal right, an action will compulsorily lie and on whether he suffers any pecuniary loss or not. In other words, there may be a violation of legal right without legal damage, but there can be a damage without violation of legal right. So the real meaning of legal damage can be illustrated by two maxims. One is damnum sine injuria and injuria sine damnum. So damnum sine injuria means a damage in the form of money, so comfort and health. So injuria means violation of the legal rights, and sine means without. So thus it means harm which is caused without violation of a legal right. So hence harm caused without violation of legal right. So howsoever great is not actionable in the law of torts. So mere loss of money or property does not cause any damage. There are many acts which, though harmful or not, are wrongful and give no right of action to him who suffers their effect. So damage so suffered is called damage sine injuria, damage without injury. In other words, damnum injuria is not actionable. In law of torts, wrongful acts are those by which the legal rights of the plaintiff is violated. So if some harm is caused to others by the exercise of legal right of a person, then no action at all will lie against him. For example, if I am running a mill at a particular place and any neighbor also establish another mill in the same place which reduces my income, then I cannot file a case for compensation against him, although it causes monetary harm to him. But if he obstructs the flow of water to my mill, then I will have the right to take action against him as it violates my legal right. So every person has a right to carry on his trade, profession in competition with others, even though this competition may cause loss to his rival. So according to this maxim, Damage is not the basis of action unless such damage is the result of violation of the legal rights of the plaintiff. So here, so Frederick Pollock has observed as follows: men do many such acts which causes some inconvenience or harm to the others, or which is likely to cause harm or inconvenience. But without doing such act, it is not possible to carry on its ordinary activities in society. Hence, no complaint can be made for such harm or inconveniences. So, here we have Gloucester Grammar School case. Gloucester Grammar School case. The plaintiff was running a school at a place. So the defendant started another school near the school of the plaintiff. As a result of this, most of the students of the plaintiff they left the school and joined the defendant's schools. So, due to competition, the plaintiff had to reduce their fees from 40 pence to 12 pence per student per quarter, and thus he suffered huge monetary loss. So, here the plaintiff filed a suit against the defendant in the court for compensation. So it was held that the plaintiff was not at all entitled to any compensation. Even the person has a right to carry on his trade or profession in. In any kind of competition with others, or if as a result of a healthy business competition, his rival suffers a loss, then he is not at all entitled to recover any compensation. Here, the plaintiff, by setting up a school near the plaintiff's school, had exercised his legal right, and therefore no action can lie against him. So, as like that, we have another case law whereby it is a Chase-Moore versus Richards. So, plaintiff was the owner of the mill. He had been using the water from the stream for about 60 years. So, the defendants dug a well on their land. As a result of this, plaintiff mill stopped getting water from the stream. So, it was held that defendants were not liable for the loss caused to the plaintiff because the defendant had a legal right to dig the well on his own land. So, as like this, we have Acton versus Blandel. So, here the defendant had dug coal mines on this land. As a result of this, the water going to the well of the plaintiff was interrupted and his well became dry. It was held that the defendants were not liable as they were exercising their legal right on their land. So, in the same way, we have another case law, which is known as the Mughal Steamship Company versus MC Grieger, Go and Company. So, in this case, again, the defendants owner of certain steamship established an association with the aim of driving the plaintiff's company out of the tea carrying trade between China and Europe. They had reduced the freight by offering a rebate to the customers so who would deal with them. As a result of this competition, so the plaintiff had also to reduce the freight and he suffered a great loss. So here the court held that the plaintiff had no cause of action as the defendants had by lawful means protected their business interest by increasing their profits. So in the same way, we have another case law that is the Dickinson versus Reuters Telegraph Company. So the defendant negligently delivered a telegram meant for the plaintiff to another person. So the telegram contained an order for sale of certain goods. So the plaintiffs, believing that the order was meant for them, sent the goods to the defendants, which they refused to accept. As the result, plaintiff suffered a heavy loss. The plaintiff company sued the defendant for damages. So again, it was held that the defendant company was not at all liable. They owned duty only to the sender of the telegram, who were their customers, and not to the recipient of the telegram. So another case law we have, that is Bradford Corporation versus Bickers. So in this case law, again the plaintiff corporation uh, had been deriving water from the adjoining land of the defendant. So here the defendant dug a pond on his land, which diminished the water flowing to the land of the plaintiff. So hence this case was filed against that person. So now we will start with legal remedy. So legal remedy is the third point. So here we can see UB, jus, EB, remedium. So where there is a right, there is a remedy. Where there is a right, there is a remedy. So right without a remedy is of no use. Right is a person's capacity to compel another person to do or to abstain from doing an act. And the capacity to compel means legal capacity to compel. So here, unless there is a legal remedy, there cannot be a legal compulsion. So therefore, a right without a remedy would be redundant, and therefore the right and remedy are said to be correlated. If there is no any right, there will be no any remedy at all. So in this regard, there are two types of right. One is said to be the absolute right. So absolute rights, an absolute right is a right, the violation of which amounts to a wrong and gives rise to cause of action. So there is no further requirement of showing any loss or injury. So the tort which is based on violation of an absolute right is actionable per se. So the conditional right is the second one. A conditional right is a right, the violation of which by itself does not amount to a wrong, so as to give rise to a cause of action. So hence, here the plaintiff has to further show that he has suffered loss due to the violation of the right. So the loss is a condition precedent for giving rise to cause of action. So this is what is all about this particular topic. So the general conditions of liability in torts. So in the next class, we will be discussing about the mental elements.